Hello. In medieval England, the agent of the crown at shire level was the sheriff, a position of authority with responsibility for collecting revenues, raising forces to fight for the king and feeding them, and maintaining law and order, serving writs, making arrests, trying cases, appointing juries, referring cases to the King's Court, and under the 1166 Assize of Clarendon, with the power to seize the property of those found guilty of crime. It was not initially a paid position, but there were plenty of opportunities to make money from bribes, extortion, and cheating the treasury by siphoning off revenue. Corruption became endemic. In response to widespread public discontent, all sheriffs were suspended in 1170, and an inquest into their activities was ordered by Henry II. As a result, there was a purge. Most sheriffs were replaced and reforms were introduced, including entitlement to a salary, and to avoid accusations of cronyism, no one was allowed to serve as sheriff in their own county. A policy decision was taken to train a ministerial class to sit as justices. Chronicler Orderic Vitalis described them disparagingly as people of ignoble stock raised from the dust. Some sheriffs had a torrid time. In 1311, 5 of the powerful Swynnerton family, landed gentry and well in with the king, appeared before Hugh Croft, the Sheriff of Staffordshire, charged with wounding, extortion and other crimes. They threatened to kill him on the spot unless the trial was dismissed. Hugh resigned immediately afterwards. His replacement, Hugh Audley, received the same treatment 2 years later. The Swynnerton family feature prominently in the Staffordshire plea rolls without once being found guilty. John Swynnerton was appointed Sheriff of Staffordshire and Shropshire in 1321. The role of coroner, formally established in 1194, almost certainly already in existence, but then given extra duties, much broader than the remit of a modern-day coroner, to service the royal courts and to insert a layer of controls and checks as a counterbalance to the power of the county sheriff. The title comes from the Latin custos placitorum coronus, keeper of the pleas of the crown, or crowner. Originally, 3 coroners and a clerk were elected by the freemen of each county, and knighthood was the qualification for the coroner role. This requirement was reduced under Edward I to the most meet and lawful men of the county. Chief among the coroner's responsibilities was protecting and maximising the crown's revenues. In terms of local administration, the role also encompassed conducting judicial inquests into unnatural, suspicious and sudden deaths. This included suicide because, if proven, any property owned was forfeit to the crown. The coroner also dealt with deodands, an assessment of the value of any object contributing to a suspicious death, which again was liable to be forfeit to the crown. So a weapon, such as a sword or bow, used in committing a crime would be described and valued in the coroner's rolls, a record of their investigations. For us, these records offer a valuable insight into medieval society and the administration of justice. In the case of a death due to an accident, for example, being fatally kicked by someone else's horse, the most likely verdict would be misadventure, but the horse would be assessed and the owner required to pay the valuation. A horse that threw and killed its owner would likewise attract a verdict of death by misadventure. The animal would become deodand and sold. Sometimes, where the value of a deodand is not clear, a detailed description will be entered in the coroner's records to enable valuation later. In one example, a bow used in a killing is described as of Spanish yew, 2 ells in length and a thickness of 4 men's thumbs. 2 ells is 7 feet 6 inches. A sudden death in a community, even one with no suspicious circumstances, could easily lead to disruption and fines. Hushing up the event, hiding the body, surreptitiously dumping it in another township, or bribing the 100 bailiff to keep quiet was not uncommon. Whoever discovered a body, the first finder, was expected to raise the hue and cry and summon the bailiff of the 100, and could face a fine for not doing so. Then the coroner had to be notified. Failure to do so again incurred a fine. The local community was supposed to guard the body until the coroner arrived, which might be several days. Failure to do so? You've guessed, a fine. Once the coroner had arrived and inspected the body, an inquest would be held. This might take place straight away, but usually there was an adjournment to allow for arrangements to be made. Inquests could turn into large-scale events. Before the introduction of a 12 or 24-man jury of representatives in the mid-13th century, it might involve summoning all the adult males from surrounding townships. One of the first tasks was to identify the body. To protect his Danish subjects in England, King Canute introduced the concept of Englishry. If a Dane was murdered and the killer had not been apprehended, the 100 in which the crime took place was fined. In the late 7th century laws of King Einar of Wessex, which we looked at in part 1, the life of an Anglo-Saxon was valued more highly than that of a Briton. Einar was an Anglo-Saxon ruler, and this may simply have been a perception of status, but it may reflect on the state of Saxon-Briton relationships. After the Norman conquest, William I continued Englishry but applied it to Normans, a very necessary protection after a hostile takeover in a land where the Norman conquerors were outnumbered by perhaps 300 to 1. The process of establishing Englishry varied between counties. Typically 2 relatives had to be found to testify under oath. Where doubt about the identity of a body remained, it was assumed to be Norman by default and the 100 responsible fined. The fine was known as a murdrum, from which the word murder is derived. Churches, abbeys and barons were exempt, placing the burden of raising the money to pay the fine, which could be substantial, on the poorest in society. A severe winter in 1257-58, accompanied by a famine, led to many thousands of deaths. The system couldn't cope. Inquests could not be held. Emergency arrangements were introduced. Murdrum was still imposed in some cases, but after a public outcry, fines were relaxed. However, murdrum remained on the statute book until 1340, by which time ancestry was so blurred as to be meaningless. But it was a potential source of revenue the Crown was loath to lose. In conducting inquests, medieval coroners were less concerned with discovering the perpetrator of a murder than in ensuring that the details of witnesses and relevant property were recorded. However, resolving cases of individuals suspected of committing a crime who claimed sanctuary to avoid arrest was the coroner's responsibility. I shall consider the use of sanctuary next time. If you've enjoyed this video, hit the like and subscribe buttons and click on the notification bell to be informed when the next video is available, or you can subscribe by clicking on the rose window over my shoulder.